about the Supranational Criminal Law lecture series. This is a lecture series on international criminal law and has been organized since 2003 on an almost weekly basis in cooperation with the Coalition for the ICC and the Grotius Center of International Legal Studies of Leiden University. And tonight's speaker is Kamari Clarke, and she's a professor of anthropology and law at the University of Pennsylvania. And Professor Clarke has prepared a lecture entitled Refiguring the Perpetrator, Culpability, Postcolonial History and Africa's Impunity Gap. So Professor Clarke, thank you very much for being with us tonight. You have the floor.
Okay, so thank you, Dr. Palusa, for the introduction and the invitation to present some of my work in progress. It's wonderful to be back in The Hague in the spring. When I was here last year, it probably was among one of the coldest winters here, so it's certainly good to be here in the spring and not in the winter. And it's good to be in Holland again during this period. The talk that I'll present tonight emerged from the ICC African Union research that I've been doing over the last year and a half, and it's still underway. And so in many ways these are somewhat preliminary remarks, excerpts from the data that we've collected so far and some of the early thinking and theorizing that has emerged. The research has been funded by the U.S. government National Science Foundation, which is an institution that often funds scholarly work, research. And it's a 3-year study that has been funded. So we're actually in the final year of the 3 years. And I'm certainly looking forward to the discussion that will follow the presentation. Now, let me just say a few things. I'm going to read a good majority of the talk as well and talk through some of the details of the cases, just for the sake of laying out the argument, because it's a somewhat complex one, but one that I think is an important one for thinking about the future of international criminal law moving forward. And let me also say another statement about this kind of work in context in which these are post-violence contexts. It's certainly a privilege to sit and analyze much of this data from the comfort of Europe or the US, and in many ways, even with its critiques and its endemic critiques, the goal here is to really think through the institutions that we're building and take stock and reflect on some of the challenges and gaps and structural problems as it relates to post-colonial African states. And so it's with that spirit that much of this work is being presented. Okay. So this talk is about the contemporary development of the rule of law movement and the related shift to the individualization of criminal responsibility, by which the responsibility for those crimes deemed the worst crimes against humanity have been attributed to those in higher positions, so that of commanders and leaders. It's also about the way that this reattribution or the attribution of guilt to commanders has had consequences for how we make sense of the figure of, and of late, of course, the African perpetrator. Whether it is the militia as it relates to someone like the figure of Thomas Lubanga, or of late some of the heads of states that have been indicted by the ICC. And so ultimately it's about how and why justice, or ICC, or international criminal justice, has failed in many ways to produce the expected terms for widespread support in post-colonial Kenya today. Now, and in many ways it's a surprising result that I'm highlighting, that in a context in which one would expect that the ICC has emerged to deal with an impunity gap, in fact, we're seeing something very different. And so the talk is an attempt to think through why that is, how that is, and what some of the challenges are moving forward. And so the talk is, of course, connected to what I'm calling Africa's impunity gap, but it's also the ICC impunity gap. And it's an attempt to think about the widespread failure, not just of the post-colonial state, but of international criminal justice writ large. It is no secret that the notion of the perpetrator indicted by an international tribunal has propelled a particular international imaginary of those whose actions or inaction contributed to vast crimes against humanity, war crimes, and crimes that shock the human conscience. The perpetrator figures represent a particular presence that is at large in various post-colonial situations today. And so this talk is concerned with the way that the African perpetrator, especially as conceived of as indicted by international bodies such as the ICC, are mediated through a particular post-colonial continuum. So in this context, there are particular three strands that I'm interested in. One is those such as agents of the court, and here the court is referring to the ICC, who base culpability for contemporary violence in a narrow ahistorical time frame and adhere to strictly legal notions of command responsibility, placing culpability in the hands of those who gave the orders or encouraged violence or permitted it to happen. Another strand, then, are those others who take the long history of colonial and post-colonial injustices into account when assigning guilt for present-day actions. And so here I'm talking about those who, the Mau Mau veterans, for example, who blame the contemporary violence on deeper structural implications that emanated from British colonial occupation and rule in Kenya over a 100-year period. And then the third group, still others, are those who experienced or lived through the violence themselves, who are more likely to hold accountable the proximate actors who actually inflicted the physical and emotional violence. So rather than a head of state, for example, here some, including victims, might be more interested in the indictment of the police officer or those who actually committed the rape, the military who were engaged in violence, foot soldiers, everyday people who one would expect a competent state to address. So these different assessments for assigning guilt have resulted in a gap between social time and legal time on the one hand, and proximate actors versus commanders responsible for actions of their subordinates, creating what, for the purposes of this talk, I'll refer to as an ICC impunity gap. And so here we see in the chart, of course, we have the rule of law movement, and fundamental to that, it's no accident that the individualization of criminal responsibility is central to the conceptualization of these cases. But in the next two bars, of course, we see a disjuncture. So the idea that on one hand there's the attribution of responsibility to commanders, which doesn't quite equal, which is disjuncture, which is troublesome. And then there's the temporal challenge, which I'll talk about today. So legal time versus historical notions of time. The result is the impunity gap. So let's take, for example, the case of Kenya's Uhuru Kenyatta and William Ruto, whose indictment by the ICC has contributed to the international image of the African perpetrator. Despite charges of culpability on the international stage, however, in 2013, a majority of the Kenyan people democratically elected Kenyatta and Ruto to be Kenya's president and deputy president. Through an analysis of the Kenyan post-election violence case study, this talk in many ways explores how culpability for crimes against humanity is being rethought in terms of the longue durée of colonial violence in relation to the proximity of violence. This has implications for how we understand the resulting gap in impunity as it relates to the perceived legitimacy of the judicial measures and the relevance of this new perpetrator figure in international criminal law. Now, let me say a few things about the election and what is the context in which violence ensued in this Kenyan case study. So on December 30th, 2011, a democratically elected, a democratic election was held, and it led to the end of a dictatorial regime of Kenya's President Daniel Moi. A new era began. However, the events leading to the elections highlighted a country that appeared fractured along ethnic tribal lines. Ethnic tensions seemed to worsen when, amidst accusations of election rigging, competing parties, that is the Party of the National Unity, what's known as the PNU, and the Orange Democratic Movement, the ODM, one led by Kibaki, the other led by Raila Odinga, both claimed electoral victory. So here we had contestations over who actually won those elections. But when Kenya's Electoral Commission announced that Mwai Kibaki was the winner of Kenya's 2007 elections, a 2-month period of violence broke out throughout Kenya, especially in the pro-Odinga areas, the slums of Nairobi, the Rift Valley, a place called Eldoret, and in Nyanza, Kisumu. And in the end, rioting, excessive use of force by members of the police and security forces, looting, burning of property, sexual violence, and murder that led to the death of 1,200 people and the displacement of thousands was the result. In response to this violence, then, on November 26, 2009, the prosecutor for the ICC requested authorization from Pretrial Chamber 2 to investigate Kenya's 2007-8 post-election violence. The justification for the indictments against Ruto and Kenyatta were argued through a conception of superior responsibility. So no surprise to us, really. And of course, it was further established through the doctrine of command responsibility. Okay, so let's remind ourselves of the first case then, in the charge against Kenyatta. And here I want to highlight the temporal component, because in many ways it comes back in the second half of the talk when I bring in some of the data from the interviews that we did in Kenya. So in the case of Kenyatta, the charges were based on his supposed command of murders committed on January 27th and 28th, 2008, in Naivasha, and in Nakuru, January 24th and 27th. Not before this period temporally and not after this period, so precisely during those days. For Ruto, the demarcated period was from January 1st to 4th, 2008, and involved violence allegedly committed in the greater Eldoret area. All the events prior to the Rome Statute coming into force on July 1st, 2002, of course, fall outside of the temporal jurisdiction of the court. So not only does the 1998 elections not count, but certainly a much earlier 50-year colonial period attack on the Mau Mau, etc., certainly doesn't count in this strictly temporal configuration, as one would expect. And so thus temporality of violence is narrowly tailored according to what I want to refer here to as legal time. So configured in terms of legal time and aligned with the actual planning, command, and execution of violence related to either William Ruto or Uhuru Kenyatta, in those two cases in particular. So in this regard, Ruto and Kenyatta were charged before the ICC with multiple crimes in connection with the post-election violence in Kenya in 2008 and 2007. The ICC's temporal jurisdiction over the case then was limited, as many of us may already know, by Article 11 of the statute, which indicates that the court shall have jurisdiction only with respect to crimes committed after the entry into force of the statute. The ICC examined its temporal jurisdiction over potential cases against Ruto and Kenyatta when it granted the prosecutor permission to commence the investigation over the situation. But it also clarified the temporal scope when it asserted crimes in relation to the evidence provided to cover the entire period in the prosecutor's initial charge. So the notion of legal time, though not new in one of the fields that I occupy in legal anthropology, is scarcely interrogated in Western jurisprudential circles. In international law, as many of us already know, there are limits to how notions of legal time is conceptualized. Criminal law focuses on strict understandings and demarcations in time, rather than reflecting on historical developments or broader root causes. Continuing crimes, such as, for example, colonialism or apartheid, of course, create legal dilemmas, not just for questions of jurisdiction, but also of evidence and its admissibility. Now so what we had then was a situation in which the ICC initiated investigation, and of course the Kenyan judicial system, the parliamentary system, pushed back. So in the case of Kenya's parliament, there was clearly resistance. The Kenyan government challenged, as many of us already know, the ICC's claim to jurisdiction over the crimes. And what we had ultimately was the African Union stepped in partnership with the Kenyan National Dialogue and Reconciliation, what's known as the KNDR team, and under the leadership of UN Secretary Kofi Annan, recommended that the government should establish a national commission of inquiry to investigate the causes of post-election violence. And this is popularly known as the Walkie Commission. Let me jump forward here. Okay, so jumping to the Walkie Commission. Now, in assessing the viability of a domestic mechanism, this commission then produced a report, so did investigations in order to assess culpability. And they issued a report. The report was issued in October 2008, so approximately a year and some months after the post-election violence. And in one of the findings indicated that a meeting was held in the State House to coordinate revenge on the Luos and Kalenjins, two of the ethnic groups in Kenya. And it cited then Minister, Uhuru Kenyatta, who of course is now the standing president of the country, was then a minister, and it cited him as one of perhaps 20 people being criminally responsible for financing and mobilizing electoral support through the Mungiki. So the Mungiki being seen as contemporary gangs, but that emerged in the highlands of Kenya during earlier periods, and it's Swahili for united, people united. So this is on the part of the findings of the Walkie report. The Luos and the Kalenjins, on the other hand, were said to mobilize their support to attack the Kikuyus. And the African Union-sponsored Walkie Commission recommended that if the Kenyan government failed to set up a tribunal to investigate and adjudicate these cases, the ICC should take over. And one of the challenges, of course, was during this period that the parliament was deeply divided, and the parliament was deeply divided for reasons that I'll explore later as we think about the historical fissures that over a 50, 60, 70-year period became sedimented in Kenya's contemporary politics. And so fundamentally nothing went through, and there was serious infighting and structural challenges to the extent that they didn't have quorum a number of times when Parliament was going to address the bill to set up this national mechanism. And there was a slogan that was passed around that said, "Don't be vague, let's go to The Hague," because ultimately the feeling was that they weren't getting anywhere. And it was Ruto, William Ruto, who was cited as being the author of that phrase that then got coined and circulated, etc. And of course it then backfired because Ruto was among those on the ultimate list. And so what we had was the Walkie Commission produced a list a macro list, and when Ocampo was the chief prosecutor, from that list derived 6 names. And on March 8th, 2011, the ICC issued a summons for 6 of the suspects to appear before the ICC. So 6 persons. So on one side, as we see in the PowerPoint, was Major General Muhammad Ali. He was the head of the Commissioner of Kenyan Police, and of course Uhuru Kenyatta and Henry Koksi. So on one side of the set of cases. On the opposing side, in relation to opposing violence, was Mathuro, who was at the time the head of public service, cabinet secretary and chairman of the National Security Advisory Committee, William Ruto, whose case is still under the jurisdiction of the court, and then Joshua Arap Sang, who I won't talk about significantly today, but he was and is the head of operations at the Kalenjin language radio station in Kenya. So let's start with the cases then. Start with Ruto. So the case against Ruto and Sang began in 2013. So from the slide you see that he's now Deputy Prime Minister. At the time of the indictment, he wasn't Deputy Prime Minister, and this is part of the context, of course. So the case against, so it began September 2013, is ongoing. The case against Uhuru Kenyatta has been adjourned, as some of you may already know, to October 2014. And of course, both sets of cases are beset with controversies and complexities, including evidentiary challenges. Now, what's interesting here, and the foil for thinking through what's going on, is that in a poll that was conducted by one of the popular pollsters in Kenya, Ipsos Synovet, in February of this year, 2014, more Kenyans opposed the ICC process than ever before. Ipsos reported that 46% of Kenya's population was opposed to ICC engagement, compared to only 29% in 2013. And increasingly, by fall 2012, the once age-old competing parties, ethnic groups, came together to create the Jubilee Party, led by indictees Ruto and Kenyatta. So despite, as I've said, despite the indictment in March 2013, Kenyan people popularly elected democratically them as president and vice president. Now, the question of who is responsible for violence committed against various victims has led to disagreements over ICC indictments of perpetrators for crimes against humanity, especially those involving African sitting heads of state, as currently is the case in Kenya. For some, of course, as we'll see, longer histories of colonial violence are part of the basis for culpability. And then for others, as I've said, questions of proximate violence have gained traction as the basis for attributing guilt. According to a report by the ICTJ, so the International Center for Transitional Justice, though victims understood that the ICC judicial context created greater responsibility is borne by those who gave the orders and that led to violent outbreaks. More than half of those who responded to the question, who should be prosecuted, identified direct perpetrators or foot soldiers of violence as being directly responsible. And though supportive of the ICC concept in principle, many victims also felt that instead of pursuing a lengthy ICC process in order to achieve compensation for violence and property loss, local and national mechanisms were seen as preferable. Even when, given the reality that in many ICC situation countries, many felt weren't fully satisfied with the domestic measures that were taken. So here we see the ambivalence, a national mechanism that isn't functioning adequately, yet a particular sense of the international domain as not necessarily the most appropriate, especially in context in which it's simply through command responsibility that guilt is attributed, and not the lower level actors. In a 2013 survey that I conducted with victims of the 2007-8 post-election violence in Nairobi's low-income Kibera neighborhood, it was clear that an overwhelming majority of Kibera residents insisted that the issue of criminal responsibility needs to be understood clearly through notions of collective guilt, as clarified through the Mongiki phenomenon. And again, the Mongiki being this gang group that is said to have been mobilized by the higher in command, in this case Kenyatta's camp, as well as the role of police in post-election violence, and for some that insisted the British colonial settlement of the Rift Valley, which ultimately led to both the demise of the Kikuyu and Kalenjin ethnic and traditional networks. So despite the perception on the ground that international criminal law rightly prioritizes command responsibility as the new innovation, rather than holding proximate perpetrators accountable, the expectation is that the direct perpetrators will be held accountable under domestic criminal law instead. But the reality is that the ICC has actually presented itself because of the lack of satisfactory domestic judicial processes. So what we see is that in many ways the law and the institutional structures have fallen short. This is not only because perpetrators of proximate violence are not being prosecuted in the national context, but because international courts cannot situate crimes historically. So as we know, a court or other tribunal is a creation of the law. In most cases, they act within the temporal legal limits imposed upon them. That is, their jurisdictional limits. So in many ways, this paper highlights a central challenge for the ICC, that is, to consider crimes that continue over an elongated period of time, such as particular situations where criminal acts have taken place both before and after the Rome Statute's temporal limits. For when international law is applied in a decontextualized, somewhat ahistorical way, it disaggregates common notions of culpability. When command responsibility is applied to reattribute guilt, it addresses the remote rather than the proximate actor. It's this reality that I argue is the main contributor for the impunity gap. And the goal then is in many ways to delve into this impunity gap, to think conceptually about how notions of the culpability of the perpetrator are mediated through various post-colonial African frames that expand legal time. In this case, 2007, 2008, and notions of criminal responsibility. And of course, there are fundamental restrictions to this. But if we think for a moment about the ways that histories contributed to ethnically stratified violence in relation to Kenya's land problem today, and if we reflect on some of the data that I'll present of those who experienced post-election violence firsthand, we might identify the limits of the ICC's conception of legal time and its prioritization of command responsibility, recognizing that neither takes into account the legacy of deep-seated histories and the concept of collective culpability that has emerged out of them. Okay. So let's go to the details of the case to think about why this is and what some of the considerations should be if we want to build a system that actually will function. And so if we think about the criminal charges, so Ruto, let me start with Ruto, the details of the charge. We have the prosecutor versus William Ruto, and et al. So Henry Kosi as well as Joshua Sang. And then the second case of inquiry here is the prosecutor versus Francis Matura, Uhuru Kenyatta, and Muhammad Ali. And as you probably already know, of the first set, one was dropped, so the Henry Kosi's for lack of evidentiary, not meeting the evidentiary standard, and so Sang and Ruto remain. And for the second, it's of course prosecutor and Kenyatta, the Ali was dropped, and as well as Mazera. Okay, so let's think about the Ruto then. So in the Prosecutor v. Ruto and Sang, the OTP argued that as early as 2006, and under William Ruto's command, an organization or network was formed within with the ethnic Kalenjin, with the goal of forcibly removing members of the Kisi, Kamba, and Kikuyu ethnic groups from the Rift Valley region of Kenya and creating a large pro-ODM power base in the region. So accordingly, April 15, 2007, an oathing ceremony was said to have taken place at a milk plant. Members of the network were said to have sworn an oath of allegiance to participate in the plan. This was followed by additional meetings in Ruto's house, allegedly, in which guns and money were distributed, and with the goal of commissioning crimes of murder and forcible transfer of specific ethnic groups identified as supporters of the other group, the PNU. As a result of the meetings, the prosecutor argued that multiple attacks took place in the aftermath of the 2007 elections that involved members of Ruto's network. It said that they attacked victims in Eldoret, in Nandi Hills, in Turbo, and this is on December 30th and December 31st, 2007. And of course, in this case, resulting in 70 to 78 fatalities, the destruction of homes, etc. So in the Kenyatta case, that we have the prosecutor alleging that Kenyatta, under the leadership of the outlawed Mungiki sect, pursued an organizational policy to keep the PNU in power through every means necessary by orchestrating police failure to prevent the commission of crimes. At the time, he claimed that in 2007, Kenyatta, the mediator between the PNU and the Mungiki, organized a series of meetings between Mathuru, government officials, Mungiki leaders, and members of the business community. And so fundamentally, it was Kenyatta and Mathuru initially who were accused of providing the funding, uniforms, and weapons to the Mungiki. And in the case of Mathuro, we will recall that he was the commissioner of police, and so he was, and that they had put in place a policy of non-interference, so where the police could attack at liberty without risk of being caught. And so this was, and then the part of the argument is that on December 30th, Kenyatta was accused of giving the MPs and Mungiki approximately $35,000 to buy guns, and attacked and defend the Kikuyus in Nakuru. And then again in January 2008, before the violence, the key Mungiki leader was allegedly given money for mobilizing the Mungiki, so these gang members, in order to act and to defend the Kikuyu, who were seen as being forced off of the land, and they were going to be attacked by the opposing forces. So ultimately we see the prosecutor building a case based on particular temporal designations and particular types of acts, but certainly the key here, individual criminal responsibility is central. Okay, so moving along. So in international criminal law, questions of criminal responsibility as they relate to attributing an individual's conduct to a state or attributing a state action to an individual have become some of the most pressing of our time. Some of these questions have interrogated how to attribute the criminal conduct of one person to another, or how to attribute individual action to a state, or collective violence by groups of individuals to one individual. The reality is that both action and inaction can have criminal effects, but the challenge concerns the real material limits to the transferability of this conduct, as well as the perceived legitimacy of this transferability. I'm just jumping over the command responsibility section, and I want to move quickly to this slide as we think about the challenge of continuing and composite crimes, and then move into some of the historical questions. So far we've talked about the problem of proximity as it relates to individual criminal responsibility and attribution of guilt. Now, of course, what we see is a conception of responsibility in which an individual, regardless of their official capacity, can be held criminally responsible for the actions of others. And using this logic, the Rome Statute set out substantive laws and procedural rules through which to address violence in this way, ascribing guilt, of course, based on a particular period within a particular jurisdiction of the court, and highlighting questions of responsibility in individualist terms. Yet, despite the stipulations for legal responsibility, many of the very victims on behalf of whom individual judicial institutions seek to act protest the designations of criminal responsibility strictly in relation to individual responsibility, especially when there is an understanding that longer histories of imperial land disenfranchisement created and were not simply byproducts of these contemporary forms of violence. Many of my respondents insisted that focusing on 2007-8 post-election violence falls short of attending to the deep-rooted historical and political issues at the heart of it. Take, for example, Kiamu, a young Kenyan human rights advocate's assertion about the problem with criminal law, temporality, and injury. And I quote, and let me just say something about this great slide. I like this phrase, "We ask for justice, you give us law." In many ways, it speaks to our contemporary reality in the rule of law movement, the reality that when we utter the words justice, we all presume that it means adjudication. And that in fact, part of what much of this data demonstrates, when you think about the data that's coming out of Kenya with victims, it's the need to go beyond the juridical. Not necessarily to disavow it, to suggest that there's a recognition that the national infrastructure has failed, that the international mechanism is actually further complicating the problem, and that there are structural and inequality issues that are still at hand that actually could lead to a further outbreak down the road. And and I think that imagery is apt in that context. And sometimes we have to sort of laugh at ourselves, even as we try to do the work that we do, to think about its consequences and how we need to do it better. And so let me quote from Kiamu. He says, "One of the biggest weaknesses of Kenyan criminal law is that we don't have a scheme for compensating victims of crime. And the idea that these people of the 2007 violence are the only victims of crime, they're not the only victims of crime. I'm also a victim of crime. I lost 10 teeth. I nearly died. The state isn't compensating me. The best the state will do is to find the guys who beat me, and they might even hang them, but they'll never pay me a coin for the injuries I've suffered. We've had victims in this country since the colonial times. We've had victims in this country since the colonial times. So if you're going to address the system of victims of political violence in Kenya, we do it holistically. We begin with the day the British landed here, the evictions that the settlers did. Today, the biggest landowners are the settlers. All of these issues need to be addressed. We're not going to just come here and create a situation and it becomes an industry for everyone to make money, and the reference point becomes 2007. And so, of course, he's talking about the human rights industry, the lawyers, etc., everyone making money on these cases. He continues, my reference point is the 18th century, and I think something needs to happen. If we're going to address the question of criminal politics, of domination, exploitation, and impoverishment, and eviction, then my reference point is not 2007, it goes much further back. And the ICC has no capacity to address that, so I'll not waste time on it." End quote. So here we see not only a strong conviction about the limits of culpability in both domestic and international criminal law, but also a critique about the inability of the law to attend to historical forms of violence. Despite these and other conceptualizations of guilt, it is unlikely that the ICC could permit itself to consider activities that occurred prior to its temporal jurisdiction, thereby violating basic principles of legality. This is especially the case given that the ICC does not have the jurisdiction to attend to earlier forms of historical violence. As a result, Keyamo dismisses the ICC as trivial. He goes on to insist, quote, all that counts as violence for the ICC is what occurred during Kenya's post-election violence period. Do they really care about the roots of African violence? End quote. These comments reflect widespread sentiments about the limits of ICC and the limits of conceptions of culpability for 2007 violence. Given this, then the larger question is who should be held responsible for contemporary crimes of violence. Okay, so just some thoughts on continuing and composite crimes, because this isn't new in law and certainly something to think about. One of the most challenging examples of how courts wrestle with problems of strict temporality can be seen through attempts to address continuing and composite crimes as they force courts to address conduct that exists over a longer period rather than in more familiar crimes such as murder. A continuing or composite crime is one that necessarily occurs over an extended period, such as, for example, the crime of apartheid. Apartheid, unlike murder, didn't occur in a single instance. It involves legal policy, state action, social control, and prolonged practices of exclusion and separation. Continuing and composite crimes also include specific discrete acts that by definition must occur over longer periods of time. For example, in contrast, the Rome Statute outlaws the crime of murder as a crime against humanity, and by definition, to be a crime against humanity, an act of murder must occur as part of a widespread or systematic attack on the population. But in contrast, when addressing regular crimes such as murder, which occur in a discrete temporal instant, courts rarely ever, if ever, address the importance of temporal limits. However, with continuing and composite crimes, courts must regularly address the temporal scope of conduct being prosecuted. And there were a number of interesting cases that we've been looking at in thinking about the ways that courts and international tribunals have attempted to deal with these problems of continuing crimes. One of them is the famous Rainbow Warrior case, and it's probably the most famous in international case law concerning continual violations. And this case was a case related to two French agents who were convicted by a New Zealand High Court for assisting in the sinking of the Rainbow Warrior, and that was that famous Greenpeace ship that was docked off the coast of New Zealand, and so the ship sank, and France refrained from detaining the two agents and returning them to the French Pacific island, which was part of their agreement, and this, of course, was in violation of the agreement with New Zealand. Now, in determining France's culpability for refusing to detain the agents, an international arbitration tribunal measured France's liability not just from the moments that the agents were removed, but rather the misconduct was deemed continuous and ongoing, and it included each day that the agents remained outside of New Zealand's control. And there are a number of cases that one can look at to think about the necessary innovations around continuing crimes that go beyond instantaneous acts of murder. In many ways, continuing and composite crimes force courts to address conduct that exists over longer periods of time than other more familiar crimes, as I've said, such as murder. And they create legal dilemmas, not just for questions of jurisdiction, but also around questions of evidence and admissibility. in the ICC cases related to post-election violence in contemporary Kenya, it's clear that a close reading of the ICC's charges allow us to reflect on the tension between specific instances of criminality on the one hand and histories of inequality and perceived injustices that have occurred over extended periods of time on the other hand. Let's turn to the example with John here, who was a journalist who we interviewed last summer. Here he insisted that that in 2007-8, neither Kenyatta nor Ruto were heads of state. So it wasn't clear to him why over others they would have been seen as bearing the most responsibility. Now he says, and I quote, "Neither of them were running for president. I don't think there was responsibility if you look at the violence and protest of ODM strongholds. I think you would see in the quote, no Raila, no peace, not no Raila, no Ruto, no peace, and especially in the Kalenjin strongholds. So how on earth do you begin to design these cases against the two of them, so the two of them being Ruto and Kenyatta? I think it is possible to finger Uhuru Kenyatta for post-election violence in Naivasha and Nakuru. I think that is possible. It is much more difficult to connect him to the North Rift." End quote. Now, by referring to the slogan, no Raila, no peace, John was explaining that those who supported Raila were fighting for his presidency and not for Ruto's. After the election results and the announcement that Kibaki had won, again, it became clear that Raila, through the ODM supporters, mostly the Lua and the ethnic groups in the ODM strongholds, refused to accept a situation in which Raila was not going to be in power. And much of this was connected to the problem of the post-colonial concentration of power among a few families. Now, from the part of the continual problem here when we think about continual crimes, part of the structural problem that I'm articulating here is that the sense that the Kikuyus had been in power for excessive, there were a small minority of groups that had been in power for multiple periods of time. When Jomo Kenyatta came into power after the Mau Mau movement and severe violence as a result of the Mau Mau mobilization, Kenyatta took office from the colonials, and power remained in a very tightly sealed vacuum between the Kikuyu and the Kalenjin. Now, what they're also referring to is fundamentally related to the moment in which Kenya became a British East African protectorate. So on July 1st, 1895, the region that now known as Kenya was declared to be a British East African protectorate. British colonialism in Kenya produced a situation of uneven land distribution and a related problem of elite patronage. The colonial government forcefully evicted Africans from their ancestral lands and relocated them to what became known as the native reserves. The confiscated land was referred to as the White Highlands and represented some of the most fertile regions of Kenya. The British colonial administration imposed laws that also forced Kenyans to labor on European farms and with poor social services. They imposed taxation laws, instituted racial segregation policies, restricted movement through a Kipande identification system, and fundamentally curtailed basic freedoms. Despite their displacement, land and ritual oathing continued to be an important part of the unification of various Kenyan social groups. But by the 1940s, the Mau Mau struggle began as a way to attend to some of the structural violence that was being implemented by the British. And of course, the Mau Mau struggle, as many of us know, led to the killing of hundreds and hundreds of thousands of Kenyans. And this is part of when thinking about continual crimes and the kind of fundamental segmentation that led to particular kinds of control of the land and inequalities that resulted. This is precisely what people are referring to. the Mau Mau struggle, which began in the 1940s. It was most intense between 1952 and 1957. It led to the imprisonment of one of the a number of the key leaders, including Jomo Kenyatta, who spent, I believe it was close to 4 to 5 years in jail. He was a former Mau Mau combatant, but with popular support, when he came out of jail, he became Kenya's first prime minister. And it was Kenyatta, so the current Kenyatta's father, Jomo Kenyatta, who ushered the country into independence. Now, of course, part of the problem then, as I've said, is the dominance of Kikuyu ethnicity, the questions of land domination, etc., and forms of violence associated to that. And this, of course, for many is seen as an example of continuing violence. Now, let me pull this together, wrap this up here. So fundamentally, let me just go to this next slide with the land. This is Jomo Kenyatta. So of course the question of land is not merely a means of production. Of course, it's fundamentally connected to people's ancestors, to the ways that social organization is constituted. And you have the production of landless squatters here. And so you have this challenge with land where patronage and patronage systems become the basis for determining who gets the land. And so the key point, I think, in many ways, this slide, Land and Patronage, really highlights the cycle of dispossession and its fundamental relationship to contemporary violence. And so for many of our respondents, really, it's dispossession, the dominance of Kikuyu versus Kalenjin contests over land, and then an ongoing conflict as a result of these land questions. We have the production of the coalition between Uhuru and Ruto as a way to deal with the ICC indictment. Of course, this is seen as a compromise and the new solution in contemporary Kenya, and ultimately attempts to reshuffle power. Okay. Now, so really the final point here before I conclude is that of collective responsibility. So on one level we have respondents saying that there are high-level leaders who actually were the perpetrators of violence. On the other hand, there's a recognition that there are particular proximate actors that cause the violence that aren't being attended to. But on the third level, there's this problem of collective responsibility. The idea that, as a result of patronage, that Kikuyu, that Kenyatta had an obligation through systems of oathing, through kinship networks, etc., that there was an obligation for those in positions of power to protect those who were being attacked by the competing others. And in the case of the Kikuyu, many of them were seen as strangers in the Rift Valley, despite their access, some of their access to land, and were driven off that land. And it was seen as a defensive mechanism. This is part of what the data demonstrates, that there's a sense that it's not individual criminal responsibility on the part of Kenyatta, even on the part of Ruto. It's actually a collective responsibility to protect. And this is part of the popular articulation of what's actually going on here. One of my respondents, when asked, well, who should bear responsibility, he said, responsibility for what? Some of the worst violence happened in Western Kenya. And yes, and this is, and I'm quoting, let me see if I can find the slide for you. No. Okay, I haven't found it, but I'll read the quote. Responsibility for what? Some of the worst violence happened in Western Kenya, and yes, it is often mentioned that Kisumu burning is actually not considered a media epicenter of the violence, and in both cases, let the state security off the hook. In Kakamega, in Bogoma, in Katali, the vast majority of people that were killed by police bullets, usually found in their back. They were running away. If you admit that, then all of the violence becomes a long-held ethnic dispute. You know all the rhetoric that influenced. It is called Agenda 4 items. And of course here, Agenda 4 items were proposed as a way for Kenya to move forward. It was the fourth and final agenda item, and it was seen as addressing the long-term issues and solutions, that is land reform, national unity, etc. And in part what he's saying is that these are fundamentally ethnic questions. These are questions that go back to earlier periods, and to understand them we have to understand questions of communal responsibility and obligations to protect. Okay, so to conclude then, I'm skipping over some of the more interviews. There's more of the same in many ways in which people are contravening or at least trying to make sense of responsibility. The question we were asking was, who should bear the greatest responsibility? Okay. So in legal anthropology and in anthropology in general, there's a vast literature on different approaches to questions of temporality, and in our purposes, temporality as it relates to culpability. The scholarship on temporality has established the role of time as socially constituted. Yet, as we've seen, the construction of international criminal law has involved the production of strict understandings and demarcations in time through which to attribute guilt. Rather than reflecting on historical developments or broader root causes, ICC jurisprudence has adopted a relatively strict view of temporality with the recognition that non-retroactivity, or the principle there is no crime that is prescribed by law, one of the foundational and central principles of law, need to be protected. The criminalization of acts occurring over long periods of time is seen as potentially threatening to this principle because it's hard to define what precisely is being punished and when exactly the conduct becomes criminal. But this is where the problem lies. The impunity gap represents an abyss between legal perceptions of temporally relevant responsibility and the growing grassroots conception of who is actually criminally responsible for acts of violence, including historically relevant institutions such as colonial agents and discriminatory segregation politics. I've shown how, in relation to these historical realities, the impunity gap highlights a hierarchical/vertical disjuncture due to the limitations of attributing conduct from one person to the other, distinguishing between foot soldiers and those most responsible, and the problem of legal time as it relates to strict applications of the temporality of violence. What the impunity gap reveals is that there is a difference between social and legal justice and the varying understandings of guilt and responsibility. It highlights the afterlife of a failure to balance power historically in postcolonial Kenya, set alongside the use of the law to rectify histories of dispossession manifest in acts of violence. We also see how fraught with meaning the assignment of culpability to one perpetrator really is, especially in contexts in which a post-colonial state has failed to adequately address the needs of those victimized by violence. Whether the disjuncture occurs because of a difference with attribution based on proximate violence or because of an inability to reconcile contemporary violence in relation to guilt attributed within a strictly narrow temporal period, so that is 2007, 2008, the reality is that this impunity gap exists in Kenyan political history because people realize that legal time and the individualization of criminal responsibility do not account for deep histories that produce the conditions under which the police, ethnic rivalries, and land dispossession were made possible. Rather, there's a realization that the inscriptions of power in colonial Kenya were central to the play of power in post-independence Kenya. And since independence, power has never been balanced or distributed beyond those particular ethnic groups that inherited power from the colonials. In post-colonial Africa, the afterlife of imperialism, colonialism, and the violence of dispossession persists deeply in the psychic life of social justice and alongside ethnic divisions. There's also an awareness that the ways that imperial injustices remain part of the post-colonial reality, a continuity of structures of economic, legal, and political power persists. And while the image of the African perpetrator as warlord, as killer, has been constructed through the law to produce a narrative of the merciless mercenary, the African head of state as perpetrator has been subject to another moral imaginary that represents a new shift. The Kenyan cases being pursued by the ICC today, in many ways, I would argue, demonstrate this point. What they show us is that the impunity gap can actually be explained through the affective sentiments of solidarity, in which not only do Africans want to end violence, impunity, and the abuses of the post-colonial elite, but they also want to reassert a new narrative about the political nature of contemporary violence. The Jubilee Party victory in 2013 demonstrates how social justice can exceed the juridical, but also be adumbrated by it. On the one hand, the political elite were able to implement a Yuhurutu PR strategy and politicize ethnicity, which led to a merger and consolidation of the Jubilee Party and its deployment of a strategic narrative of victimhood. And many of us saw how that played out. But on the other hand, we are seeing the emergence of a renewed sense of ethnic solidarity and a different moral imaginary within their respective communities, an imaginary around responsibility to protect that persists. There's a socio-cultural realization that particular historical attachments reflect the reality that we live in a world that extends beyond the law. As I've shown, articulating guilt through narrow terms like superior responsibility, especially in contexts in which states are still institutionally, infrastructurally unable to function in the ways that we would hope in this moment. Of course, there's a challenge there. There is an impunity gap. And so to wrap up, the international criminal legal concepts of culpability rely not on rational reasoning for clarifying the line of command, but they depend on a particular production of the guilty perpetrator without whom violence would not be possible. New international law assertions of culpability, though, are not enough to make sense of these deep roots of violence that much of the data has highlighted. There's an affective dimension, an emotional connection to colonial injustice and proximate action that remains part of the post-colonial condition. Large numbers of the Kenyan public see the post-colonial complexities that have taken shape as now being misdirected by ICC indictments, and a fundamental misunderstanding in some cases of what command responsibility really is. But ultimately, this has implications for the construction of the African perpetrator, and in this case, the attribution of guilt to, in this case, the Prime Minister and the Deputy Prime Minister. And so to close, my key point in many ways, if we were to think about the two considerations moving forward, as we ponder what I'm saying is a failure, both on the part of African states as well as our international criminal law institutions, it is that international criminal law has to appropriately and adequately address questions of historical violence and resultant inequality. So in some way, conceptually, innovatively, that if we're going to achieve buy-in, if we're going to achieve the kind of widespread support that one would assume in a context after mass violence, that these a priori incidents of violence have to be attended, and especially if they're not already being attended by states and haven't been fundamentally seen. And then finally, the contemporary state capacity needs to deal with these questions of proximate violence. And in the absence of the state to deal with proximate violence, the consequence is that we have a system in which an international mechanism reaches in and the impunity remains because there is no mechanism in the middle, in the state infrastructure to deal with these proximate forms of violence. And that is actually where I think the emotional work is necessary if we're going to move forward and achieve the kind of ends that we're hoping to with the development of international criminal law. Thank you. Yeah, I'll sit.
Thank you very much for that interesting presentation. I think for people who work a lot on regulations and articles and provisions and paragraphs, it has been very refreshing. You took a step back and showed us, let's say, the broader picture and the broader background. I'm sure that the audience will have some questions for you ready. Some of you might be able to use the mics from the MATA training. For others, my colleague Frédéric can assist you with another one. Yes, please.
Thank you very much. It was a very inspiring analysis. Yeah, thank you. Is it on? Oh. Hello? Yes. So I have a question about the first of your recommendations that you gave at the last bit of your presentation, because I do appreciate your analysis of the partiality that international criminal law and the ICC specifically plays in tracing back the root causes of conflicts and the structural forms of inequality, etc. But I wonder whether this is really in the competence, in the mandate of a court, the International Criminal Court, but any court, because this is a legal institution and it's been mandated with the mandate of prosecuting individuals responsible. And I wonder whether, and of course all issues of rights of the accused come in with regard to the proposal of investigating root causes of violence, but also does the court have the resources to do that? It's already overwhelmed with the cases it has and with proving the culpability of one individual, or of the individual. So I wonder whether this recommendation would be not more appropriate for the establishment of a truth commission, for example, that in transitional justice is the institution usually mandated with investigating root causes and looking at more low-level perpetrators and also providing for more victims' participation in this sense. So I wonder whether a cooperation between a truth commission and the ICC would not be more productive in closing the impunity gap than giving this burden all to the ICC.
Okay, sure, I'll take a couple and then.
At the back.
Hello. Hello. Yeah, my point ties into the last speaker's point as well. Because the Kenyan Truth and Justice Reconciliation Commission actually did address these structural issues and didn't look at the 2007 post-election violence because of the commission set up immediately after it and due to the focus of the ICC on these issues. And then, yeah, the Truth Commission was in a localized area, was in a better position to give like a more balanced view and historical record rather than an adversarial record that the ICC would bring. Yeah, and was then able to highlight those and was better placed to do so. Yeah, so in that sense, I think I would agree with the last speaker that it is, perhaps better to do it in a local level as opposed to expecting that the ICC could deal with these. Just how would you deal with the risk of conflation and all the further difficulties that expanding it, that in your first recommendation, how you would combat such issues?
My comment is in a completely different vein, and I get the sense that there's on the one hand the question of policy recommendations and so on, and on the other hand questions of framing, and I quite appreciate this way of reconceptualizing what it is that the court is claiming to do and then what it is that's actually happening on the ground. So my comment goes more to how you're theorizing the impunity gap, and what I'd like about that phrase is the idea that there's an inbuilt critique. We so often hear this term as impunity gap in terms of more prosecutions, but I think what your argument suggests is perhaps something more like the accountability gap. And what I mean by that is when you say the term impunity, there's already built in etymologically this notion of punir, to punish. And you talked at the end about the problem of the principle of legality as a kind of limit to this. So in a way, we're already within the frame of positive law, and so we immediately think of one iteration of the principle of legality as nulla ponis sine lege, the idea that you can't actually have a crime that's then punishable without a law to punish it. But I think with accountability, there's this broader question not only of to be held to account, but then what is not accounted for within that frame. And so what I'm hearing is the problem of certain things that are not being accounted for, such as colonial histories. And so it seems like in a way the critique is perhaps even broader than this notion of impunity. Thanks.
Let's take those three questions.
So, yeah. And I'm going to stand, sorry for the informality, but I have this allergy that causes me to cough, and I find that it's much easier when I'm standing for some reason. Maybe I can't explain it. So thank you for the questions. Let me start with the first two. And in many ways, the third question, in some ways, is the answer, I think, to the first two. So, of course, I anticipated this type of question and these concerns. And I have to say that if our response is that international criminal law, if the mandate of the court cannot accommodate some of the fundamental structural problems that probably, I would say, inevitably will lead to further violence in the region, if the court cannot begin to address root problems that are substantive, that deal with buy-in and the lack thereof, then perhaps we're not ready for the institution itself. I mean, could we consider that I mean, the innovation that emerged from the trust fund, if we had discussed it perhaps 40 years ago, we would have said never. That would never. This is not the mandate of the court. Restorative justice, and this is not in the mandate. And it's true that the trust fund is a separate unit, but there are innovative ways that through significant mobilization we were able to combine and bring together an institution that also has a prong to attempt to deal with these restorative justice questions. The incorporation of victims, this is an innovation as well. So I'm not one to say never, and I do think that part of the work of scholars and thinkers and policymakers is to think through and imagine how we can do this better, and imagine what kind of adaptations and incorporations would need to be necessary for this to work. And so in part what I'm saying is, yes, the Truth Commission failed fundamentally and temporally was unable to take into consideration some of the claims that are necessary claims. What do we do in the absence of a statecraft that succeeds in addressing some of these historical challenges? Perhaps it's not a case that's ready for ICC adjudication. Perhaps it requires a whole set of other political, infrastructural issues to address it, rather than bringing in a judicial mechanism that actually could be far more disruptive. So there are a lot of considerations here, and I think that they're worth thinking about if we want to envision something like an ICC that works alongside states, with states 50, 60, 70 years from now. Hopefully it won't be necessary. Perhaps it might be. What is it that we're envisioning? And so part of what I'm doing is trying to think about how can we consider continuing and composite crimes as a way to take into account the work of and maybe there's a way to build in a threshold in which there's an identification of particular type of crimes that actually may be fundamentally problematic and lead to further violence in the future because of some of the deeply structural issues that aren't being attended to vis-a-vis land reform. So these are very important questions. Clearly, I'm not poo-pooing the importance of a truth commission, but clearly there was a failure there. So it's something to think about. The last question, thank you for that suggestion that I couldn't agree with you more on that point, that by invoking impunity gap, in part what I'm saying is I am talking about accountability and what is accounted for and what isn't, and not simply articulating a critique of the state, right, or Africans, a critique of the post-colonial African state, but in fact talking about a gap, a conceptual gap that's at play, that continues to be at play, and that continues to be promulgated through the law, through political mechanisms, etc., and that will continue to be promulgated and will have consequences for ultimate buy-in here. And I think that that's the significant concern that emerged from the data, that some of the conservative estimates are actually worrying the very victims who have suffered, or the very victims who are saying, no, this judicial process is not for us.
Any other questions, or maybe, yes?
I think I can use this one. Yes. First of all, thank you very much for your presentation. It was amazing in the terms that it's very refreshing to hear a broader approach. And I come from Ecuador, of course, a little country in South America. I know lots of things about post-colonial history, and actually it goes deep into my soul to hear that all these problems that now we're facing in international criminal law and perpetrators and the history of countries that it's not now, it's not 10 years ago, it's 18th century, it's a long time before us. To hear that most of the perpetrators or the war criminals that are now at the ICC or are of course people that have been part of a process. Sorry for my English. Yes. I would love to say this in Spanish, but then we have very powerful countries that, of course, they've been the historical countries that they are the ones that also are the once they're the thinkers, you know, about the ICC, the courts. We need all these mechanisms in order to protect the world from war criminals. But then again, they are not signing the Rome Statute. They are influencing inside the ICC. They are making phone calls, blah, blah, blah. But then the only ones that we are there, the only ones that are paying their debts are the smaller countries, you know, or at least not the most powerful ones. So for me, it's very interesting to have this kind of studies. And I was wondering what is going to be, because you said this is the last year, what is going to be the outcome, and if it's going to be implemented somewhere, or how you are going to use these results.
I'm going to work with the first two question askers and see if we can come up with solutions here. Can I just answer that quickly? Thank you for that. You know, clearly the perceptions of justice are as important as the deliverance of justice. And so your point about the perceived unfairness, weaker countries versus some of the more powerful countries in the world not being party to the ICC. Certainly significant numbers of the Security Council at the UN, etc. So this is an ongoing challenge that certainly isn't new, but and it's something that in the larger, so it's an NSF project, and we've been writing I've written some op-eds there's a book that will come out of this. The last book was published by Cambridge, and this one will probably be, and half of it a draft, half of it has been drafted thus far. So. So ultimately there will be a book, and then there are articles that are coming out. We have some special issues in law journals, etc., that are coming out through collaborations with other legal scholars who are doing critically engaged work. So simply not approaching the law as if law isn't a product of creative innovation and mobilization, but a critically engaged approach to international criminal law. And so we have a working group. It's an international working group of scholars from various places with different training in law, political science. Most of us have joint law degrees, and so do combined work. And so the idea is to work on publications and to think through and to mobilize groups of people who are interested in thinking in a more critically engaged way of improving the world in which we work. That is that of international criminal law. The other thing I wanted to say is that we're also, part of the study also involved doing work at the African Union. So we're in Addis Ababa now. We've been there since January, and we'll continue till the end of July. And we're doing consultations with the legal division there. And actually having a direct impact on some of the decision making, both around this new African court that is being the extension of criminal jurisdiction of an African court that actually is pursuing crimes well beyond Rome Statute crimes, and I think it's the other crimes that we're more interested in, some of the economic crimes, mercenaryism, toxic dumping, a range of other crimes that are part of exploitation of natural resources, a range of crimes that are part of the African landscape that are key tensions and forms of violence. So there's also some quite deeply collaborative work that's going on as well that will continue, that will result in publications and other things.
Good evening. I really like the woman ahead of me question, but I guess to build off of that, I thought what was really attractive is how you brought up the notion of collective responsibility. And it seems very attractive, especially when you're thinking of the huge impunity gap that command responsibility leaves for those who are underneath it. But I guess my question to you would be, how do you think that this could be implemented? And I guess to look at that, everyone can't be held to the same standard, which makes command responsibility attractive because naturally some people are more guilty than others, but it seems like a violation of due process to hold everyone to the same standard. So I am interested to know what your views on that. Thanks.
Okay, yes, thanks for that. Let me just be clear on what I was saying there, because I just summarized, I skipped through a significant amount on collective responsibility and ended up simply making the point and then highlighted some of the interview data. Part of the point, though, is the problem with the mobilization of collective responsibility is that it led to violence. If we follow the theory of the OTP, and if we follow the theory that oathing and the mobilization of the elders, etc., to put in place particular leaders was part of an attempt to protect interests. I have ambivalence clearly, because if in fact collective responsibility is both productive and feasibly violent, then there are challenges to the mobilization of collective responsibility, which obviously you've raised. But I don't necessarily think that individualization of criminal responsibility is the only solution, because collective responsibility. But I think that we have to understand how these systems work. The OTP, of course, was able to gain hold of the logic of collective responsibility because they used oathing as the basis for the legitimacy of the bond that created the obligation. So there was a network. So in the case of, in Ruto's case, in Kenyatta's case, allegedly, it was the mobilization of the Mungiki. They were paid, and they had, and the alleged argument is that Kenyatta was put in a position to protect his state's people, right, his ethnic group, etc. And he contributed, but also the diaspora, the parts that I didn't read. I mean, tremendous support from, alleged support from the diaspora, from Texas, from, many, many places. It wasn't simply, according to the data that we collected, it's not simply one person or the other person, that this is about a collective responsibility to protect those who had been historically disenfranchised. The presumption is that they wanted to move the Kikuyu from that region, from the Rift region, and there was an obligation to protect, regardless of even if it involved death. And so this is part of the challenge here. The idea that there would be a break from a cultural system is not a viable idea. That in fact there is a cultural system that could have been mobilized. Of course, the case is ongoing, so I'm using the conditional here. So presume that everything is in the condition. This is data we're collecting. This is interviews. This is the OTP argument, etc. And so in part, the idea is that this long-standing system was mobilized to put in place a system that then would protect those who were going to be evicted from the region. And of course they're being evicted because they're being seen as strangers. They're seen as strangers because when the British moved to the Rift Valley region, they were evicted. They couldn't afford to buy back the land, so those who bought back the land controlled the land, and some of them became squatters. Those that became squatters, they wanted to evict as well from the land. So it's a complicated cycle there, but deeply, and not, unfortunately, not novel in a range of settler states in Africa. I mean, Zimbabwe, South Africa, we can name many of them in which this land question has yet to be resolved and continues to cause severe challenges in the contemporary period. And if not land, then we can talk about resources and what happened after the Rwandan genocide and how genocidaires moved to the DRC, the Congo region, etc., and to pilfer and extract resources. So land and access, etc., these are part of the landscape and are part of what we're, are necessary to understand in order to think about how to stop these forms of violence. Any other?
Good evening. My question is whether or not, if the ICC uses your approach over here, can it attract more states to join to join and ratify the Rome Statute or not? Thank you.
I'm not sure what my approach is. I'm not necessarily. I don't have a full-fledged policy that would be sellable, I don't think, at the next General Assembly. So I'm laughing at myself in a way to say that fundamentally what I'm saying is that we need to consider root causes, right? That's really at the heart. And the strict application of the judicial with blinders actually could cause more harm than good. And that there are a range of other considerations that need to be part of our calculus. As part of enlisting other countries to join, I mean, obviously my approach or my concerns about history are both inviting and challenging. Inviting because, many people who are alive would be outside of the jurisdiction of the court's reach if we were to think about longer continuing forms of exploitation that persist. So there would be no risk for a given country of people who are living to worry about that. There may be civil implications, but as far as criminal responsibility, that would be off the table. I think that there are a range of other political and deeply economic questions that are part of why states are and are not joining the ICC. They go well beyond some of my interest in these historical and root causes. these concerns that are historically driven and driven by root causes. And I think that that's what we would have to look at if we want to think about the mobilization of other countries. One of just to end my response to your question, one of the data sets that we've been collecting has had to do with asking the question, why did African states sign on in such large numbers? And one of the things that we're finding is that that it wasn't necessarily the Nuremberg celebration that many say, that as we talk about, when you think about the public speeches that the court has made, various actors of the court have made, and that this was about a Nuremberg tradition carried forward, etc. What we're finding in the data is that it was fundamentally, there are two prongs. One is that it was fundamentally about Rwanda and anti-apartheid in South Africa. It was places like late independence struggles in Zimbabwe, Namibia, some of the violence in the civil wars on the continent, so Sierra Leone, etc. But especially Rwanda was a moment where a sort of a moral imagination in which African states were saying, the world stood and watched what happened in Rwanda. We need a system in place that's effective. But the second, and I think the most ironic finding, is actually an economic one. It's the realization that in this age of neoliberal governance, African states, there's a linkage, as we know, there's a linkage mechanism. So the higher the index, the better your investment possibilities, the better your chances as a state to renew your IMF loans, your EU loans, etc., if you can demonstrate good governance, particular practices, appropriate democratic elections, forms of succession that are in keeping with transition and in keeping with principles of accountability, etc. And the reality is that many states signed on for the same reasons they signed on to a range of other international treaties, to increase indexes and to sign IMF loans. That it wasn't simply and fundamentally about a belief in the existence of the ICC and the rule of law in and of itself, that there were a whole range of push factors, some being emotional and the need to end impunity and to end violence, but others being quite pragmatic. And in the absence of that second prong, in the case of Russia and the US and China and some of the other states that are not under the court's jurisdiction, that second prong won't help. Of course, it's not it's not a key factor for some of the economically dominant states, but it's certainly something to remember and to think about as you ask the question: why would any state submit to the court's jurisdiction and then to have the court turn around, to then have to fight the court, as we saw in the Kenyan case? So it's an interesting finding, and as a social scientist, it certainly is an interesting finding.
My question is, what do you think, in your opinion, the concept of collective responsibility adds to, or how it differentiates from the joint criminal enterprise that is already in use in front of ICTY and ICTR? Thank you.
We're talking about two very different things here. Collective responsibility. One doesn't necessarily replace the other. This concept of collective responsibility on the part of elders and people in villages mobilizing is really about putting in place a structural system to protect particular interests. In legal terms, and the application of joint criminal enterprise, I mean, we saw this with the Charles Taylor case, etc. In legal terms, there are a whole set of other questions and thresholds that are relevant here. So I'm not saying that the two it's either one or the other. In fact, one is a legal concept that has particular thresholds and evidentiary standards. The other is a form of social and political organization that is invoked by traditional conceptions of responsibility. So in the longer version of the paper, I go through oathing and how oathing worked and how issues of individual and criminal responsibility traditionally were conceptualized, and how then the concept of traditional and collective responsibility then became part of the consciousness of the group that is the produced group as the Kikuyu. So there are two different things, and in no way am I suggesting that they're parallel. I think the only similarity is in the psychic world of attributing responsibility. Beyond that, I think we're dealing with apples and oranges in many sense. Are you asking the question because you want to argue something else? I'm interested in the parallel that you're drawing there.
No, I'm satisfied.
Okay. Because something it may be something to think about, but it's certainly not where I am.
Hello. Yeah, I was just wondering, do you have anything specific in mind when you say that international criminal law should deal with structural issues? Like which kind of structural issues? Because, I don't know, for instance, like adding more crimes, a list of crimes to the Rome Statute, for instance, like corruption as an international crime, or the plunder of natural resources and so on.
Yeah, that's precisely it. That I think, and fortunately, the Rome Statute does have a review process, and there are steps to ultimate revisions over time. I think that going beyond the core crimes is one of the first steps. Pillage, by the way, is already, but hasn't necessarily been executed. But what we see with the proposal to expand the criminal jurisdiction of the African Court is the incorporation of all of those other crimes that were once part of the International Law Commission's 12 crimes that may have been part of the subject matter jurisdiction of the court, are actually in the African Court's subject matter jurisdiction. But they were in what would have been the Rome Statute crimes. And in my book, Fictions of Justice, I have a chapter where I talk about this genealogy of delineating the crimes and how ultimately we came to the 4 crimes that we have. But there was a time when apartheid and mercenarism and some of those other crimes were actually part of the subject matter jurisdiction of the proposed institution. And I think that's an important step. What we have now are political crimes in many ways that are seen as the worst crimes against humanity. But in fact, the reality is that if we think about the DRC today, or even Sudan and Darfur, you tell me that there aren't economic questions there that are part of plunder and pilfering and the use of mercenaries, etc. Corporate criminal liability when we think about Sudan. So I think that there are, when we envision an international criminal institution 50 years from now, might we envision an institution that actually includes some of the crimes that are part of the core violence in some of those regions? The reason they're not, of course, is that states couldn't agree. They were too controversial to be incorporated, so they were dropped. There were a whole range of reasons why, and if you follow the transcripts from those negotiations, it's fascinating, the objections, the arguments, etc., that were waged to ensure that that none of these controversial crimes would have been included. But I think in time, if this institution is going to exceed as an institution and as one that has legitimacy, we need to think about some of the other crimes that are core crimes. But we also need to think about the domestic infrastructure. We haven't talked that much about that, but the space of the national, the role of positive complementarity and the ability to ultimately produce mechanisms that will lead to not only rebuilt judiciaries in these post-war contexts, but economic infrastructures, livelihood. Yes, it's not the mandate of the court, but if we're thinking about larger conceptions of transitional justice and living in a world in which violence and disparities aren't at the core of everyday life, then at some point our multiple strategies have to begin to deal with these various concerns.
If there are no further questions, then I would like to thank everybody for those many and excellent questions and answers.